I'd just like to welcome everyone to this MGAA market briefing. So before we get started on the sessions, just a little bit of housekeeping to do. So apologies to anyone that's attended a few of these in the past. It is the same content, but I'll just go through it for the benefit of anyone who's not been to one of these sessions before. So just a polite ask, please, if you could not put your cameras and microphones on, because it helps us with technology, and we'd really like to stay with you to the end of the session, so that would be much appreciated. And can I also ask that if you have, or automatically it might have happened, activated any AI note-taking facility, if you could deactivate it, because we don't have the permission of everyone attending, so that will also be appreciated. In terms of things I'm encouraging you to do rather than things not to do, please, if you've got any questions as we go through, if you can pop them into the chat, what we'll do is we will cover those at the end of the session. So yes, at the point you think of something, pop it in there, and then it'll be ready for the Q&A session at the end. So also let you know that the session is being recorded even. Good news about that is that hopefully early next week, or maybe end of this week, I will get out a mail to you with a link to the recording and also a copy of the slides. So that'll be there for your benefit if you want to review any content, but it's also handy if you want to pass it on to a colleague to have a look at. And the final thing before we get started is just to remind you that our market briefings are accredited by the CII for CPD purposes. So if the session fits with your training needs, then you can pop it there in your log. So that's nearly me done with. Just to give you a little bit of information now about our session today. So really happy to have Clyde & Co with us, and we have Peter Barnes and Charlotte Kelly, who are partners at Clyde & Co. They will do a far better job at introducing themselves. So when I hand over, they'll give you a little bit more information about themselves, and then get started on our market briefing today, which is all about European product liability. An update for you. So I'll hand over to Charlotte and Peter.
Thank you. Thank you very much. Good afternoon all. Thank you for inviting us to speak with you today. Charlotte and I head up the product group at Clyde & Co, where we deal with product disputes, dealing with damage or injury across multiple classes of business lines. Today we're going to speak to you about the reform which is taking place in Europe at the moment. The backdrop for this reform arises from a considerable shifting landscape which covers product liability and safety, leading to reform in respect to medical device regulation, product safety, product liability, the AI directive and EU representative actions. And the EU representative actions enables Europe to have a form of collective redress or class action system, which will slowly enable Europe to catch up with the process that's currently available in the United States. So given the time available, today's seminar is intended to provide an update in respect to the liability regime in the EU, rather than focusing on the safety and other regulatory updates. Although we do have some material about those as well, which you can check out by accessing our links on the Clyde & Co website. So the EU and the UK are undergoing significant overhauls of their product liability regimes, primarily driven by the need to address challenges posed by technological advancements, new business models, especially online marketplaces, such as Amazon and eBay, and increasingly complex intangible products. In this presentation, we will explain the reforms introduced by the new EU Product Liability Directive 2024 and the impact it will have on manufacturers, suppliers, authorised representatives and their insurers. Key takeaways will include the difficulties faced by claimants under the current law and the more consumer-centric approach of the new EU directive, which attempts to even up the field, especially in respect of complex products such as those in the med tech and life sciences sectors. The changes have been long awaited and have largely been driven by a consumer-focused agenda in Europe. The changes brought about by the directive do not have any impact, just so you're all aware, in respect to contractual claims or claims under common law, so tort-based regimes, and claims under contract or common law will therefore remain unchanged. Whilst this presentation is focused on the changes in Europe, we will also come on the position as we see it unfolding in the UK, and why the change in Europe will have major consequences for UK manufacturers selling into the EU, and for others such as distributors who may be potential defendants under the new Product Liability Directive. So Charlotte, can we move forward on the slides, please? Thank you very much. So product liability refers to the civil liability of manufacturers and others where damage or loss is caused by products which fail to meet the standards claimed expressly or impliedly for them, or which are dangerous or otherwise defective. As you can see from the slide, product liability law can be split broadly into three regimes, and it is commonplace to see all three causes of action being brought in a single claim. We will, however, focus today on the statutory regime, which is a Product Liability Directive. In the UK, this is the Consumer Protection Act 1987, but this was based on the 1985 European Directive, which is the one we're talking about today, which has just been changed at the end of 2024. So if we move slides, please. So a big milestone for consumer redress was the recent adoption by the European Union of the new EU Product Liability Directive on the 23rd of October 2024. It will replace the existing Product Liability Directive from 1985, so it's over 40 years old. The purpose behind the new directive is to seek to modernise product liability rules to bring them up to speed with advancing technologies, circular economy business models, and the globalisation of supply chains. It is also designed to remove obstacles for consumers wanting to seek compensation in respect of defective products and seeks to resolve resource imbalance conundrum where claimants often face significant costs associated with product liability cases, including expert witness fees, where defendants typically have greater resources and access to evidence from their instructing clients. This is especially true, as you all know, in the life sciences area or in highly technical cases. The new Product Liability Directive therefore changes the current product liability risk landscape for companies selling products in or into the EU significantly. And as you'll see from the quote on the screen, as products have become more complex, there has been a lobby by claimant law firms and consumer action groups in Europe to ensure that the evidential burden on claimants is made lighter. As such, Europe will be changing from a regime which is historically defendant-friendly to one which is more supportive of claimants. Importantly, the new regime also ensures that victims will always have an economic operator within the EU from whom to claim compensation, and this will level up the playing field between the EU and non-EU manufacturers. And Charlotte will talk about this a little later on. Given that there have also recently been changes in Europe in respect to group litigation under the Representative Actions Directive, product liability claims are likely to increase over the next few years, and the new Product Liability Directive will have an impact on how the defensibility of such claims is managed, and insurers and their insured should have early discussions about this. Can we move slides, please? Thank you. So what's all the timing of this? Well, with regards to timeline, in October last year, members of the EU voted on the final wording of the new Product Liability Directive to replace the 1985 Product Liability Directive. This was agreed on the 10th of October and was signed into law on the 21st of October 2024 and came into force on the 9th of December 2024. EU member states will be required to bring into force national law implementing the new regime 2 years after it enters into force at a European level. So it will be likely sometime in the second half of 2026, but depending on each member state. The new rules will apply to products placed on the market 24 months after entry into force of the directive. At present, the Product Liability Directive will not apply to the UK, although pressure is mounting through claimant lobbying groups for the law to change, and the Law Commission is being asked to start an assessment provided they can obtain government endorsement. So we can move slides, please, Charlotte. So this is about the definition of products. This is one of the changes that have been brought in by the new directive. So the old directive in 1985 was a directive focused on tangible products because in reality that was genuinely sufficient at that time pre-internet. The new Product Liability Directive, however, broadens the definition of a product to include movable items, electricity, digital files, which that includes software, AI systems and digital manufacturing files, and related digital services necessary for the product's functionality. This recognises the growing importance of intangible products and the continued control manufacturers may have after a product is placed on the market, moving away from the factory gate principle. You may recall that under the old directive, a key consideration was the date the product was put into the market. A product had to be defective at the point of supply, i.e. when it left the factory or the factory gate. Now, continued control over products, including software updates, will be considered as part of the liability regime. Software includes updates, whether embedded or standalone, and includes AI systems. And software is classified as a product regardless of how it is supplied or used, whether it's stored on a device, accessed through the cloud, or provided as a service. And this will have a big impact in certain sectors where manufacturers sell products with software embedded. So by way of example, in the life sciences setting, examples of software in primary care medical devices now becoming connected include health apps, blood pressure machines that may transmit results to a mobile phone to be analysed and which offers advice to the patient, and ECG monitors that automatically connect to an app that can maybe be shared with the cardiologist. Certain types of software are of course already subject to regulation in the EU under the medical devices regulation or the in vitro diagnostic medical device regulation. However, to date, and this is important, standalone software has been out of scope of the Product Liability Directive. Under the new directive, software would be in scope whether embedded in the device or placed on the market as additional product in its own right, and irrespective of the purpose of the software or the mode of supply and usage. For example, stored on a device or accessed through cloud technologies. As a result, companies developing, for example, health tracking apps designed to diagnose or treat specific conditions should be prepared for claims to be brought under the revised Product Liability Directive for the first time. Please note that free and open source software, where the source code is openly shared and users can freely access, use, modify or redistribute the software, or modified versions thereof can contribute to research and innovation on the market, is not included within the definition, and such products are not providing in exchange for price, so they're not included. However, if a manufacturer of a product subsequently integrates that free or open source software into a product it is manufacturing and then places its end product onto the market, that manufacturer could be held liable for damage caused by the defectiveness of that software, despite the fact that they did not create it. So the extent to which software is brought within the ambit of the new directive will be a potentially significant point of interest for insurers who want to consider the potential impact on any international product liability cover they write, and how wordings will deal with the addition of non-tangible products and silent cyber coverage in a product liability setting. I'm going to pass back to Charlotte, who's going to talk about the scope of the claimant. And the next slide, please, Charlotte.
Thank you, Peter. Yeah, I think Peter started with quite a significant change under the new directive. I'm going to start with less significant changes and work my way up to a very significant, probably the most significant change. So we'll start with a small one, which is the scope of potential claimants. So as you'll see from the slide, Article 5 has defined the new way in which a claimant would fall under the directive. So the old directive, as you'll probably remember, confirmed that it covered injured persons. That was it. So it's quite simple. Now, the new directive covers, as you'll see, injured person, so any natural person who suffers damage caused by a defective product, the injured person. But it also, and you'll see it, Article 5.2a, also confirms that claims for compensation may also be brought by a person that succeeded or was subrogated to the right of the injured person by virtue of union or national law, or a person acting on behalf of one or more injured persons by virtue of union and national law. And you'll see at the bottom of the slide, we've just put in two little taglines, which is consider alongside the Representative Actions Directive and collective redress tools and third-party litigation funding. This slide is, or this change is quite significant in that it does open up the possibility of significant representative actions in the product liability context across the EU. And you'll see from the continuing aspects of this talk that this is a change that is really throughout the Product Liability Directive. So most member states have implemented the Representative Actions Directive, which obviously foresees the adoption of collective redress tools across the European Union. When you combine that with third-party litigation funding, which I'm sure you all know provides financial resources to litigants in exchange for a share of the proceeds of litigation, it's clear that group litigation is gaining momentum in the EU, and businesses and insurers need to be conscious of the risks caused by the increased regulation, particularly when you marry the collective redress mechanisms and unregulated third-party litigation funders, given that tools that under this new directive, which we will continue to talk about, are likely to be used strategically by well-funded claimant lawyers pursuing claims on a collective basis, supported by litigation funders. It's a clear change, and this slide is just the start of it. I'll move on because we've got quite a few to get to. So the next key change is the scope of the potential defendant. Now, as you'll see, there's a significant amount of words on this slide. So what we've tried to do is break it up into three key levels of potential defendant. But as a starting point, I'll just remind you all about what the defendant under the old directive was and how that has changed. So under the old directive, the defendant would be the producer of the product. So that is defined principally as the manufacturer of the product, but it also caught supplier and importers into the EU, and any person who, by putting his name, trademark or other distinguishing features on the product, presents himself as producer. So it was quite clear-cut: manufacturer, supplier, or any person putting his name, trademark, or on the product. Now, new product directive has removed that definition in favour of economic operators. You'll see at Article 8, member states shall ensure that the following economic operators are liable for damage. And then, as I say, I've now broken it down into 3 key levels. So the first level, which is the most obvious one, is the manufacturer, which is defined at A. So 8.1a, the manufacturer's defective product. Then the manufacturer of a component, where that component was integrated into or interconnected with a product within the manufacturer's control. I won't read the whole clause at B. And then thirdly, any natural or legal person that substantially modifies a product outside the manufacturer's control and thereafter makes it available in the market. So that was the first stage, quite simple: manufacturer of a component, or any natural legal person that modifies a product. The second level of economic operator, where you cannot establish a manufacturer within the EU, that is manufacturers established outside the EU, which is relevant for people writing UK business. So that would include the importer of the product or component, any authorised representative of the manufacturer. This is as I'm sure you'll be aware, it's a product safety law aspect really. So, for example, under the medical device regulations, the authorised representative acting on behalf of the manufacturer is responsible for the medical devices placed on the European Union market. So it's quite a key change that weren't traditionally included within the old directive. And then the third part of the second level is the subsidiary fulfilment service providers, so storage, packing and shipping service providers. So they also weren't traditionally covered within the directive. And then the third level is in the case that none of the other economic operators could be identified, and that would be the distributor and then any provider of an online platform. And that is quite a significant change, but they definitely wouldn't be falling under the old directive. So the new directive does significantly extend the group of potentially liable parties, and it's precisely those companies that weren't previously among the liable parties, so modifying manufacturers, authorised representatives of the manufacturer, fulfilment service providers, online sales platform operators. They need to prepare for potential claims, and in turn, insurers need to be aware that if you're writing risks that cover those type of economic operators, they may be requesting product liability cover when they have never traditionally required product liability cover. And it's important, therefore, that both insurers and their insureds in these areas are aware of their potential liability under the new directive at an early stage and act accordingly to mitigate that risk. So I would say a good example is companies that develop or distribute smart products or AI systems. Given the, as you'll soon see in the next few slides, almost unlimited extension of product liability for products manufactured by those type of companies, and the corresponding adaptation of the term of defectiveness, which I also will go into, it's really important that those type of companies are considering this new directive in detail now. Right, so the next slide we're going to is the definition of damage. Sorry, I just this slide, apologies, is just a very short table to do the comparison. I won't go through it because it's just a repeat of what I previously said, but hopefully it's helpful for later review. So yeah, next key change is the definition of damage. This is quite a short and quick change. So under the old directive, damage meant damage caused by death or personal injury, damage to or destruction of any item of property other than the product itself. And there was a 500 euro threshold, so any damage to a property less than 500 euros wouldn't be included under the directive. Anything above would. It's now changed, as you'll see from this slide. So firstly, it will cover death and personal injury, like it did before. But as you'll see from the slide, it says including medically recognised damage to psychological health, which is a quite a significant change from the previous requirement for just tangible damage or physical damage to one's person. It now includes medically recognised damage to psychological health alone. Then obviously it covers damage to or destruction of any property. But as you'll see, there's no 500 euro limit, which I think is, whilst probably insignificant for everyone on this this call at the minute, the fact is, if there's going to be increased mass litigation, claims falling under €500 falling under the strict liability regime will become quite important and will be relevant. So that's an interesting change in the new directive. And then the last change is it will also cover destruction or corruption of data that is not used for professional purposes. So that's quite an interesting change. Obviously, the directive does confirm that this is distinct from compensation for infringement for data leaks and breach of data protection rules, but it does include loss of data that's not used for professional purposes. So that's quite a significant change too under the new directive. Right, key change 5, the assessment of defect. So although the definition of what constitutes a defect is largely unchanged under the new Product Liability Directive, there's new references as to how defectiveness will be assessed and a significantly longer list of how they will assess that defectiveness. So as you can see, there's quite a few on the slide. Previously, I think the old directive, much more easy. So a product was defective under the old directive when it does not provide the safety which a person is entitled to expect, taking into account all circumstances, including presentation of the product, the use to which it could reasonably be expected to be used or put, and the time when the product was put into circulation. So quite simple and has been subject to quite significant litigation over the years. In contrast, the new directive provides quite a comprehensive new framework for evaluating defectiveness. So Article 7, as you'll see, it confirms that a product shall be considered defective when it does not provide the safety that a person is entitled to expect or that is required under union or national law. This is the first time that the new directive mentions or alludes to product safety law. And you'll see throughout the rest of this talk, Peter and I will both refer to product safety law as being quite a significant new part of the liability directive. So I'm sure as liability insurers, you probably, whilst you have safety in your periphery and how a product's brought into a market in the periphery of your consideration, ultimately you're looking at liabilities. Well, the new directive is directly saying product safety and how a product's brought into market will impact on the liability regime. So that's the first key point from this. The Product Liability Directive then goes on to provide significantly more circumstances to take into account when assessing the defectiveness of the product. And as I say, list them on the slide. Key ones are the reasonably foreseeable use of the product. That's quite reflected in the old directive, so that's not a huge change. So that's at Article 7.2b. Article 7.2c is the effect on the product of any ability to continue or to learn or acquire new features after it's placed on the market or put into service. This new assessment specifically addresses AI-driven products where software or algorithms must be designed to avoid dangerous patterns. It reflects the legitimate expectation that a product's software and underlying algorithms are designed to prevent hazardous behaviour. So a manufacturer who designs a product with the ability to learn unexpected behaviour, for example, will remain liable for behaviour that causes harm through this presumption and assessment. Next one is, I think F's an interesting one. It's relevant product safety requirements. So they will consider the relevant product safety requirements, as I already mentioned about product safety law. It's quite a significant development in the new directive, and that's the explicit inclusion of cybersecurity. So relevant product safety requirements including safety relevant cybersecurity requirements, which this resolves the debate over whether this aspect should be considered in the context of effectiveness of the product and safety, and in terms of preventing harm caused by the product. So it's now explicitly complemented by security, meaning that protection of the product from third-party interference is a key consideration. G is recall, any recall of the product or any other relevant intervention by a competent authority. So by adding product recalls or other interventions by authorities to the list of factors influencing defectiveness, the new directive further integrates product liability law with product safety law. So all completely relevant to product safety law. And then last final one is paragraph E, which is the moment in time when the product was placed onto the market. So as you recall, under the old directive, the moment when the product was placed on the market was quite decisive. It was a key consideration and it was key defence, so it had to be defective at the time of supply. So a manufacturer under the new directive is now required to keep pace with the advancing state of scientific and technological knowledge for as long as it retains control over the product. So retaining control means that the manufacturer, either directly or through a third party, has the ability to provide software updates or upgrades. So many digital and AI integrated products will likely remain under the manufacturer's control once placed onto the market. And that will then mean that the manufacturer will have an obligation to closely monitor ongoing developments in science and technology and respond through software updates or upgrades. And if they don't, well, it's one of the considerations for what would be deemed a defect. So the new directive does set out a series of detailed criteria that must be considered when assessing a product's defectiveness, and it's significantly more than the old directive. It's not exhaustive, and it specifically addresses areas not previously covered, including internet of products, AI-based products, and the manufacturer's control over a product after it's been placed onto the market. So quite a big change. I keep saying it's quite a big change. They're all big changes. The next one is it's one of the largest changes, and that is the presumption of a defect. And it really is one of the most significant and talked about changes in the new directive. And as a starting point, I would say that whilst the onus remains on a claimant to prove a defect and causation, and that is highlighted in Article 10, so it says member states shall ensure that a claimant is required to prove the defectiveness of the product, the damage suffered, and the causal link between that defectiveness and the damage. What the European Commission has done is given claimants 3 helpful and important ways to basically create rebuttable circumstances where a product will be presumed to be defective or a causal link will be presumed. I'll take you through these. So the first one is Article 10.2, and Article 10.2 confirms that the defectiveness of the product shall be presumed when any of the following conditions are met. And the first one is disclosure, and it says the defendant fails to disclose relevant evidence pursuant to Article 9.1, which is a clause regarding disclosure. Article 9 says that member states should ensure that at the request of a person who is claiming compensation in proceedings for damage caused by a defective product, and a claimant who has presented facts and evidence sufficient to support the plausibility of that claim, the defendant must, with that request, disclose relevant evidence that is at its disposal subject to various conditions. So if a claimant makes a request for compensation before a court for damage caused by a defective product and presents facts and evidence to demonstrate the plausibility of that claim, a defendant has to provide disclosure of relevant evidence. If they don't, the product will be deemed defective. Now, when considering types of requests like this, the directive does say that member states shall consider the legitimate interests of all parties concerned, including third parties, and protection of confidential information and trade secrets. But a claimant only needs to demonstrate the plausibility of his claim or her claim to obtain relevant disclosure. Now, we don't know what plausibility will be interpreted as by the courts, but it can't be ruled out that a claimant may be granted access to a company's internal business documents, such as design information and findings from like product monitoring or the like. And if you don't provide it, there's going to be a presumption of a defect. So that's probably one of the most significant changes, and it's going to be quite significantly challenging across the member states. One such example is Spain, when there's really no such duty to disclose in the Spanish courts at the minute. I know the Product Liability Directive doesn't apply directly to the UK, and by contrast to Spain, the UK has quite significant disclosure obligations, so it wouldn't be such an issue here. But yeah, in Spain, it'll be quite a significant cultural issue. So it'll be interesting to see how it plays out, and it'll be interesting to see how the court deems a claim to be plausible and what is relevant evidence. But either way, we know it's coming in, and companies will need to develop strategies to deal with any such disclosure requests across the member states, and that will be key to protecting confidential and privileged documents, especially noting the increase in well-funded claimant lawyers pursuing claims on a collective basis. So that's one of the large ones. The next one is the claimant demonstrates the product does not comply with mandatory safety requirements. So a product will be deemed defective if the claimant demonstrates the product does not comply with mandatory product safety requirements, which is interesting. Goes back to the product safety point. And then thirdly, if the claimant demonstrates the damage was caused by obvious malfunction of the product during reasonably foreseeable use. So that's those 3 examples when a court will deem a product to be defective. The next way the European Commission helps claimants is by proving causation. So at Article 10.3, the causal link between the defectiveness of the product and the damage, so they've got over the product being defective, with clause 10.2. Next, they have to show causation. And the court says the causal link between the defectiveness of the product and the damage will be presumed where it's been established that the product is defective and the damage caused is of a kind typically consistent with the defect in question. Now, we query what is typically consistent. Medical causation and evidence surrounding that is such a significant part of the defence of product liability claims, and looking at the increased extension to damage under the new directive and the inclusion of psychological injury, it's going to be interesting to see how a court deems injury typically consistent with a defect. So I think it's obvious a physical injury would be quite easy to determine, but a psychological would be quite a lot more difficult. So that's the second way the European Commission has helped claimants. And the third way is in proving both. So they say that if a claimant has difficulty proving both defectiveness and causation, a national court can presume that where, despite the disclosure of evidence by a defendant, the claimant faces excessive difficulties, in particular due to technical or scientific complexity, to be able to prove the defectiveness of the product or the causal link between its defectiveness and the damage, or both. So all the claimant is required to do is demonstrate that it's likely that the product is defective or that there's a causal link between the defect and the damage, or both. Quite a whole encompassing change. So whilst the old directive has never been incredibly easy to win for defendant manufacturers, given the claimant must only prove a defect and causation without any requirement for negligence under the directive, strict liability, it's clear that the new directive will make it more difficult through the introduction of these new presumptions in favour of consumers, and in certain circumstances effectively leads to a quasi-reversal of the previous burden of proof. Now, this has been put to the European Commission, and the European Commission does maintain that the burden of proof remains on claimants and has not been reversed. But it's easy to imagine situations where some of the new provisions could result in a shift of the burden to the defendant, and in such cases, the defendant would have to prove that the product was not defective or that the defect did not cause the damage, which could be particularly challenging in complex cases, such as those involving multiple parties, and we're back to the group litigation point. Now, it will be necessary to wait for the transposition of this revised regulation into each member state to see how the burden of proof problem will be articulated in each national court's legal system. But what is clear is that to ensure consistent protection across the European Union, member states must carefully implement the articles of the new directive, as the legislation does not allow deviations from its provisions regarding the burden of proof. It's going to be quite a significant change, and it will be implemented. On the other hand, claimant commentators, as you'll probably imagine, have chosen to take on a more critical view with respect to these presumptions. They suggest that some of them are just not strong enough to make a significant impact for consumers in the market, and they query that, or they are concerned that a consumer is still required to prove their claim. So they argue that the presumptions, for example, in Article 10.2 with the disclosure obligations, the claimant still has to demonstrate that the product breaches mandatory safety requirements meant to prevent precisely the type of damage experienced. So they say it's effectively requiring a claimant to demonstrate causation and a defect, so there's no change. A similar issues arise with the presumption set out in Article 10.4, and they comment that whilst it provides assistance to a claimant faced with excessive difficulties, it still requires the claimant to demonstrate that it's likely the product is defective and that there is a causal link between the defect and the damage. So they're saying, well, it still requires the claimant to demonstrate these. So where's the change? So it's an interesting argument. I think as defendant practitioner, we're quite concerned, probably the wrong word. I think we're very aware that this is a significant change in favour of consumers, but it's maybe not enough for some claimant organisations. Right, Peter, defences.
Thanks, Charlotte. If you could click the slide forward, that'd be fantastic.
Yeah, I have, yep.
Thank you very much. So as you can all see, under the new Product Liability Directive, a product is to be considered defective where the product does not provide the safety that a person is entitled to expect from it or what is required under national law. And as Charlotte just said, the claimant must still prove that a defect existed. So whilst there is concern amongst insurers that, when you hear a talk like this, it all sounds very scary, I think from the proactive defendant, the proactive insurer, the proactive manufacturer, the reality of the situation is that when you're defending a claim, the burden is always, perhaps not legally, but sort of commercially, on you as a defendant to demonstrate why your product did not cause the issue. So there's always been, in our view, a sort of a slightly reversed way of dealing with this, and any good product liability lawyer will always come up with a plausible alternative as to why the situation arose, and that's how successfully you can defend cases. The question really is one of legitimate expectation. This can be proven by way of direct expert evidence or inference, and now, as Charlotte has explained, by way of rebuttable presumption. So documentation is therefore the key, and a cautious and organised insured will be able to put in measures now to ensure that they can still meet this obligation, which, as we've alluded to, is still very similar to the position we have here in England, but it will be strange for some of our European neighbours, such as our colleagues in Spain. So, as you'll see from that big long list under Article 11, the defences applicable in the new Product Liability Directive remain largely the same as under the old Product Liability Directive, and this is good news for defendants. But we must flag that there are options within the new Product Liability Directive for member states to exclude at a national level certain provisions. So by way of example, the new Product Liability Directive allows at Article 11E, as you can see on the screen, member states to omit the state of technical knowledge defence on implementation. The state of technical knowledge defence is effectively that the scientific and technical knowledge at the time when the product was put into circulation was not such as to enable the existence of the defect to be discovered at that time. And this is potentially a significant change and is particularly relevant to those manufacturing or insuring complex products which are modified, altered or improved over time. And in those member states that do exclude the state of technical knowledge defence, manufacturers may be held liable even if they can prove that the defectiveness could not be discovered due to the state of knowledge at the time. And this may raise interesting coverage consideration for insurers in that space. We'll of course know more about what member states may choose to omit the state of technical knowledge defence over the next sort of 12 to 18 months. In addition, there are defences under the new Product Liability Directive will not apply where the claim relates to digital services integrated into product, software including upgrades or updates, and a lack of software required to maintain safety or a substantial modification of the product. This means that manufacturers or providers of AI systems will remain liable for defects arising after the system is placed on the market, where that defect arises as a result of either a software upgrade that is retained responsibility for providing, or an AI system's ability to continuously learn. In essence, this means that manufacturers and their insurers will have a longer exposure to claims, and I'll come to limitation in a moment, because their involvement in the product will be triggered each time an upgrade is provided. So Charlotte, can we skip slides, please? Let me always start from defence. I'm conscious of time to limitation. So the EU acknowledged that products age over time and that advancements in science and technology continually lead to the development of higher safety standards. Consequently, the new product liability updates limitation periods primarily to address the realities of increasingly complex products and services. The changes recognise that it would be unreasonable for manufacturers to bear unlimited liability for the potential defects of their products without any time-based restrictions, but balances that with extending the time within which injured parties can bring claims, enabling stronger consumer protection with clear accountability for producers and other economic operators. So while member states have discretion as to where they implement some provisions of the Product Liability Directive into their national law, as we've just mentioned with the state of technical knowledge defence, this is not the case with those concerning limitation of liability. And EU legislators have therefore agreed the following rules on product liability limitation periods. And as you can see from the screen, the limitation period for claims remains at 3 years, although the 10-year long stop for claims under the current legislation will be extended in some cases of latent damage to 25 years if an injured person is unable to initiate proceedings within 10 years due to the latency period of a personal injury. So this would have a prime example in terms of perhaps the PIP breast implant litigation or the vaginal mesh litigation we've seen in recent years. And this is likely to present unique challenges to producers or manufacturers both in dealing with discovery and defending claims generally. Charlotte, move slides, please. So what's happening here in the UK? Well, since Brexit, the UK is not bound, as you all know, by European regulations, and it's presently lagging behind its European neighbours in respect of reform of its product liability regime. And as matters currently stand, more than half of respondents in a recent consultation by the Office of Public Safety and Standards supported changes to the product liability regime provided for under our existing laws being updated. Only 9% were against, and the rest of the respondents were indifferent. The UK government has, however, recently implemented a bill called the Product Regulation and Metrology Bill, which is in the final stages of coming to law later in the summer. The bill is interesting because it enables the UK government to, as you can see from the quote on the second paragraph on the slide, make the sovereign choice to mirror or diverge from updated EU rules to maintain high product safety while supporting business and economic growth. It's therefore possible that the bill could provide a backdoor to enable the UK to follow European law on certain issues. Now, clearly, whilst the bill is directed at safety reform rather than liability, it does aim to deliver more protection for consumers against high-risk products, such as fire-risk e-bikes and lithium-ion batteries, and to crack down on unsafe goods sold in online marketplaces. And at present, in its current form, as it's going through its readings in Parliament, the following appear to be the key features of the bill. It will apply to the whole of the UK. It will create a framework of secondary legislation by way of statutory instrument in relation to reducing or mitigating risks presented by products defined widely as tangible items rather than intangibles. They've gone away from the intangible view from the European Union. It will ensure that products operate efficiently and effectively, and also will ensure that products designed for weighing or measuring operate accurately. The new bill will also provide scope for market surveillance authorities to share information about products, and once it's shared by market surveillance authorities, how will that access into Europe, given the changes in the Product Liability Directive? And it will also beef up the enforcement regime by 5 points, creating new powers of entry, search and seizure firstly. Secondly, imposing new product recall requirements and product enforcement notices. Thirdly, allowing the Secretary of State to appoint inspectors and create new offences. Fourthly, conferring on the courts the power to order forfeiture of products that do not comply with product regulations. And fifthly, allowing for the cost recovery of a regulated body in carrying out functions conferred on it by regulations made under the proposed Act. So one aspect of particular importance is the purpose of the bill. The Department of Business and Trade conducted an impact assessment in which it identified the bill was required because the UK lacked the power to end recognition of existing EU regulations or to recognise new post-Brexit EU regulations. And this bill will allow the government to do so rapidly by way of secondary legislation. And this potentially major and overlooked consequence of the proposed legislation, as it may allow for the rapid adoption and recognition of EU regulations post-Brexit, and also creates a scope for regulatory divergence. So importantly, I must flag that the bill excludes food, medicine and medical devices. So if you're operating in that sphere, the proposed bill won't cover those items. So as such, unlike the EU's repeal and replacement of the Product Liability Directive, the UK appears, in our view, to be taking a more piecemeal approach. It's addressing specific issues through regulations and guidance. So in the life sciences setting, we've seen the medical devices, post-market surveillance amendment regulations, and new regulations for running clinical trials, which will take effect from the 28th of April 2026. So as matters currently stand, there is a divergence of how product liability claims may be run on the European continent, with the UK being manufacturer-friendly and the EU entering a phase where the new directive is pro-claimant. This is going to raise interesting challenges for manufacturers operating across jurisdictions on how they approach the defensibility of their products, which may in turn lead to our current government fast-tracking their own changes to ensure a standardised approach to safety, whilst at the same time cherry-picking all or part of the new Product Liability Directive to save on costs of administrative work. So Charlotte, can we click to the next slide, please? So we're going to go through some conclusions, really, and the next one, please. So the EU and the UK are undergoing significant overhauls of their product liability regimes. This is primarily driven by the need to address challenges posed by technological advancements and increasingly complex tangible products. In this slide, as you can see on screen, we've set out a summary of the key changes from the Product Liability Directive, and Charlotte will address these in a little more detail in the final bit of our talk in relation to key considerations, takeaways of what the reforms in Europe mean and what this may mean to your insured clients or the people you deal with on a day-to-day basis. So Charlotte, I'm going to pass over to you.
Yeah, thank you, Peter. Yeah, I won't go back through this because I'm conscious we have spent 46 minutes now going through all the changes, but we just highlighted the key ones, or the key and most significant ones from the new directive. So claimant-friendly legislation, easier for claimants and bodies representing collective claimants to bring claims, disclosure, rebuttable presumptions will be used, and the fact that claimants only need to provide facts and evidence to support the plausibility of their claim. So that's, I think, the key changes and most relevant to everyone. What we've done next is we've done a short summary slide, which I won't go through, because hopefully that will just be helpful for later use. And then we've done some key considerations and takeaways. And really this is how we'd recommend, or what we'd recommend in terms of next steps as a result of this directive. We know that the new directive brings in significant changes that will apply to all products placed on the European market and put into service after December 2026. So whilst those member states and the lawmakers within the member states are continuing to work on implementing the directive, all economic operators, so all potential defendants within the European Union and anyone bringing products into the European Union should start preparing for those changes now. And when we say all people bringing in products and economic operators, it's really important that insurers also start considering those changes. So what we've done is, as I say, set out 8 key points that we think would be helpful, and they are split between insureds and insurer points. So they're mixed quite nicely. I think just starting with the insurer one, because I'm guessing that's the majority on this call. So insurers, I think the key thing is considering policy wordings and whether your current wordings are appropriate in light of the widened scope of the new directive, the widened scope of economic operators. So those people, those companies that wouldn't normally fall within the Product Liability Directive and the liability regime that has. It's really, I think it's important that insurers look at their wordings and consider the potential increase in claims that this new directive may bring. We're not saying those claims are going to be successful for the reasons we've gone into detail, but I think it's fair to envisage that there will probably be an increase in claims. So insurers will need to review and adjust policies to consider those new risks associated, especially with digital and technological products, as well as to adapting to the new changes, which will likely, in our view, involve modifying premiums, redefining exclusions and reassessing coverage capacity. Brokers probably need to be talking to their clients, their insured, about whether they should fall within the new directive and whether they need to take out product liability cover. So I think there's quite a big insurance piece, and parts of these general considerations and takeaways will obviously also do follow with that. I think in terms of insureds, they should be considering whether their products will be caught by the directive and reviewing their processes for manufacture and supply into the EU. So that includes document retention and storage, as I said at point 1. So point 2 we've already covered. Point 3 is tied in with that. Insured should review regulatory compliance and product liability risk profile and ensure they have robust systems in place. Fourth one, business-to-business contracts. That's going to be a really important part, and third-party supply agreements. I think it's very important the insureds do start looking at that and consider whether they are adequately protected in relation to potentially increased claims and the fact that they may want to bring subrogation against some of their suppliers because they are going to face potentially increased claims. Recall systems, and they need to be reviewed and check the monitoring and recall systems in place and what that impact will have on liability claims. Clearly, disclosure. It's very important the insurers consider their disclosure obligations and the fact that if they don't have disclosure, there's potential of presumption of a defect, which will obviously impact their premiums and impact insurers. One thing that we have been talking about a lot with more global manufacturers is the potential impact on US litigation. You know, as we all know on this call, US litigation is very expensive, and what we are envisaging is potentially claimant organisations using litigation in Europe to get disclosure that they may not normally get under US litigation or other jurisdictions, and then using that disclosure as a means to bring much more expensive claims in the US. So disclosure is just such a key part of this talk and this new directive. Obviously, number 7, stay aware of the legislative changes in Europe and how each member state decides to implement the new directive. That would be key. And finally, consider and assess ancillary legislation. So main one, product safety regulation. Given the impact that will have on liability, it's really important that all organisations keep on top of legislation. And that is the end. That's just a slide on our expertise, but that's the end of the talk. So
thanks, Charlotte. There was one question in the chat, which was whether the new directive will result in significant increase in product claims, which I think you just touched on anyway. But I think when we've given this talk in the past, that is a question that does come up. In our view, is that the leading academics on this, and even the EU, think that the revised directive is expected to lead to an increase in claims, especially in industries where products reach consumers at the end of the supply chain. As well as industries importing products from manufacturers based outside the EU, so particularly in consumer goods, pharmaceuticals, medical products, automotive and software. And then the other thing that comes out of that is whilst there's an increased group of defendants under the economic operator, so maybe more claims within Europe, we do think that might have a blowback here to the UK. So if, for example, people are manufacturing component parts that are being put into Europe to be manufactured into products, they might not get the direct claim in the first instance. That might get settled under product liability, but there may be more straightforward contractual claims that arise out of that. So going back to Charlotte's point on the policy coverage bit, if purely contractual claims are excluded under your policies, that might be quite a good thing to maintain, but your insureds may have some exposure from that way. So we do think generally there will be an increase in product claims because of this change in the directive, but the defensibility of them will still operate on the same model subject to the increased disclosure and discovery requirements.
I think that's completely relevant to those companies that develop in or distribute in smart products or AI systems. They're likely to be brought into the EU. So it's just it's going to increase the numbers simply because there's a bigger defendant base, very, very simply. Was that the only question, Peter, or was there more? I can't actually see the chat.
I think
there is another one. Just one more, and this is looking at the what impact will the new directive have on the UK?
Thank you.
Yeah, I suppose it might come before what you talked about in the UK, haven't you, Peter? But do you want to take that one, or?
Yeah, I mean, I think broadly I've just touched base on it in the answer there. I think if there are companies manufacturing, but I think with an eye on what the UK government is looking at in terms of regulatory reform in due course and cherry picking parts of the directive, I think we will start seeing it. But really, if you're a manufacturer, an importer, or a distributor, or an economic operator providing goods from the UK, you are exposed to this. So a lot of multinational companies, whilst they won't face claims directly as a result of this within our jurisdiction, they will be brought in other ways. And we're also already seeing that US plaintiff firms are already making plans to come over to Europe to do that. So it's not doom and gloom. This has always happened. There's always been a transatlantic crossing, including sort of Japanese law firms coming over and the like. We see that anyway. But I think broadly this new directive will slowly over the forthcoming years have an impact on how product liability, perhaps historically thought of as just part of a casualty or a commercial combined policy, is going to become a bit more played out, particularly with the software elements, particularly with the AI, and also that combined cyber threat as well. So I think we will all hear more about how important product liability and have an impact on UK businesses in Europe going forward.
Yeah, I completely agree. And I think also in the meantime, so once the new directive is in place and if the UK doesn't act quickly, I think insurers like need to be aware that we are going to be effectively acting under two different liability process or regimes, and that's going to be quite hard to follow for insureds. There'll be different ways of defences or worse defences under each regime, so that's going to be difficult. And as Peter said, in terms of the UK, hopefully the UK will get on with doing something, but what that something will be, we can only wait and see. But in the meantime, it's going to be quite interesting for people who manufacture and sell in the UK and European Union.
That's right.
Yeah, thank you. I think we are complete with the questions, unless anyone's typing. But I've got a few, some thank yous to pass on. So if anyone is typing, it may well pop up before it's time to go. So so thank you to both Peter and Charlotte for that. It was very, very interesting, and also a reminder that the UK legislation in 1987 was actually quite a while ago.
Yes, that's what I would say.
Yes, it's only when you say that, really, it's not quite as recent as I might have wanted to believe it was. But lots of information there, and handy takeaways to think about as well. So thank you ever so much. As I said at the start of the session, link to the recording and the slides will be available to everyone. So if there is anything that you want to review back on, it will be there. And also my usual request, plea for people to fill in the feedback form when it comes to you with the link, as it is really helpful for us to understand your feedback and helps us change and sort out what these sessions look like in the future. So in the absence of any questions, that just leaves me to thank everyone for joining us today, and enjoy the rest of your afternoons.
Thank you.
Thanks very much, everyone. Thank you. Goodbye.